Dear friends, today we will discuss a case about the applicability of moratorium on personal guarantors to the corporate debtors. You see, in quite recent judgment, that is in between SBI versus Ramakrishnan and others, this matter came up before Hon'ble Supreme Court. Facts of the case are briefly as under. The managing director of the CD signed a personal guarantee for State Bank of India for certain credit facilities availed by the CD. When the CD failed to repay its debts on time, SBI initiated proceedings against the CD under the SARFAESI Act. At the same time, CD filed an application under Section 10 of the Code for initiation of CRP, which was granted, and a moratorium under Section 14 was imposed. During the pendency of the CRP, an interim application was filed by the MD contending that Section 14 of the Code required all proceedings against him and his property to be stayed. The NCLT granted the application and the NCLAT upheld this decision, holding that the moratorium under Section 14 applied to personal guarantors as well. However, in the subsequent appeal filed by SBI before the Supreme Court, the court held that Section 14 of the Code did not refer to individual guarantors, and therefore the moratorium would not apply to them. The court also observed that the Part 3 of the IBC Code, which contains separate moratorium provisions for personal guarantors, that is Section 96 and 101 of the Code, was far more protective than Section 14. Finally, the court noted that Section 31, subsection 1 of the Code allowed the authorized resolution plan to include provisions for payments to be made by the guarantors, indicating that the guarantors could not escape payment obligations. The above clearly settles that the moratorium given to CD will not extend to personal guarantors of the CD. Thank you so much for watching. Thank you.